All right, let's dive into something that could be a total game changer for your VA claim. We're talking about one of the most powerful and, honestly, most misunderstood rules in the entire VA system. It's a rule that's literally designed to be your built-in advantage.
You know that feeling, right? You've gathered all your records, you've submitted everything, and you're just left thinking, man, this is close. This could really go either way. It's a super common and, frankly, a really frustrating place to be. So that exact feeling, that 50-50 coin toss feeling, is what we're going to tackle. What if I told you there's a rule written directly into VA law specifically for that situation? A rule that says when it's a tie, the win is supposed to go to you.
And here it is. This isn't just a nice idea or some internal guideline. This is the law straight from the Code of Federal Regulations. It says when a reasonable doubt comes up, that doubt will be resolved in your favor. Notice the words there. Not could be, not should be, it will be. That's a command.
Think of it like this. The VA has a built-in tiebreaker. It's officially called the benefit of the doubt rule, and its whole purpose is to give you, the veteran, the edge when the evidence is hanging in the balance.
Okay, so what does this actually mean when a VA rater is sitting there looking at your file? Let's break down how this powerful rule actually works in practice.
The whole thing hinges on that key phrase, reasonable doubt. And the law itself tells us what that means. It's a very specific kind of doubt that happens when there's an approximate balance of evidence for and against your claim. Basically, the scales are pretty much level. This analogy right here, it's probably the best way to understand the spirit of this rule. In baseball, if it's a tie at the base, who gets it? The runner. Well, in the world of VA claims, you are always the runner.
But, and this is a huge but, you've got to understand what approximate balance really means to a VA rater. This is where a lot of claims can get derailed because it's not as simple as just counting up the pages in your file. This is maybe the most important thing to get. The VA isn't just stacking your documents on one side of a scale and their documents on the other. It is never about the sheer quantity of paper. It is always about the quality, the credibility, and the persuasive power of each piece of evidence.
And that persuasive power has a fancy legal name. It's called probative value. All that means is, how convincing is this piece of paper really? Does it just state a fact, or does it actually explain the why and the how in a way that's hard to ignore? Let's make this real with an example. So on one hand, you have a quick doctor's note that just says, veteran has PTSD. Okay, that has some value. But now compare that to a detailed, independent medical opinion that explains the diagnosis, clearly links it to your military service, and provides a solid rationale. That second document, it has way, way higher probative value.
Now listen up, because this is crucial. How a rater weighs that probative value is a judgment call. It's subjective, and that means you can't challenge their decision later with what's called a clear and unmistakable error, or CU claim. CU claims are for undeniable factual mistakes, not for disagreeing with a rater's judgment.
So if it's all about the weight of your evidence, how do you make sure your proof is as heavy as possible? Let's get into the strategy of how you can build a rock-solid case.
A strong independent medical opinion, and IMO, is one of the most powerful tools you have. The really persuasive ones, the ones with high probative value, almost always have these four key things. A statement saying the doctor reviewed all your relevant records, a summary of their qualifications, a clear rationale explaining their conclusion, and bonus points if it's supported by medical literature. This structure is built to be convincing.
It's not just about the structure, though. The actual words you use are incredibly important. The VA operates on specific legal language, and some phrases carry a special weight that can literally make or break your claim.
Take these two phrases. At a glance, they look almost identical, right? But in the eyes of the VA, they live in completely different universes. One is a statement of certainty, and the other, well, the other is the key that unlocks the very rule we're talking about today.
Let's boil this down to simple math. More likely than not means there's a greater than 50% chance something is true. But at least as likely as not, that means it's a 50% chance or greater. That exact legal phrase signals to the rater that the evidence is in approximate balance. That is the magic phrase that triggers the benefit of the doubt rule. Okay, let's bring all this home. Understanding this rule isn't about finding some kind of loophole. It's about knowing how the system is designed to work for you.
At the end of the day, this rule is in the law because Congress recognized that when the evidence is a genuine 50-50 split, the men and women who served our country deserve the benefit of that uncertainty.
Simple as that. This entire approach really comes from a place of veterans helping veterans, which is a core belief at places like HadIt.com. It's all about empowering you with the information you need to navigate this process, because knowledge truly is power. So as you look at your own claim, or maybe as you help another veteran with theirs, I want to leave you with this question. Now that you know a tie is supposed to go to you, how will this change the way you look at your evidence and prepare your case?